between the parties is one of the biggest reasons why cases can be delayed. And that's because if the parties can't compromise and they can't reach agreements on anything, in other words, the limit to the amount of questions and answers that are going to be exchanged in the discovery process, or whether or not depositions are going to occur, what ends up happening is hearing after hearing after hearing, and then extension following extension. Because the parties cannot reach agreements on their own, they go down to the courthouse and they get whatever agreement the judge makes them have. The judge issues a ruling, and that is another way in which cases can be delayed. And again, it's unlike what we are used to seeing on going all the way back to Perry Mason, Matlock, LA Law, Denny Crane, any one of those shows. You have a discrete issue, and then within 30 to 50 minutes, and every once in a while maybe a cliffhanger episode, so in 2 episodes the issue is solved. That's not how it works. You don't go down to the courthouse after one hearing and win generally. It's usually a longer process. And that's what I was talking about. It's more like a football game or like an athletic game where there's going to be 9 innings and it's a lot of strategy, and you got to prepare, you got to keep the game close, win it at the end. And by that I mean at some point after the discovery period's over, questions and answers have been exchanged, answered, satisfactory answers are given or not, and depositions are taken, and that's when people are made to sit in attorneys' conference rooms or sometimes in hotel rooms and give statements. They're witnesses to the case, and the attorneys have the right on behalf of the party to ask that person questions. They get to question them before trial, and that generally only happens in civil matters. But the point being is that that's the nature of that time period, that quarter in the litigation. And then at some point, the parties are going to be past the halftime mark, and they're going to be ordered to mediate the case. Generally, civil cases, family cases, probate cases, there's going to be a push for mediation of the case. And that mediation is going to be kind of the third quarter. You look at that as the third quarter. And it's an opportunity for the clients and the parties. It's an opportunity for the clients and the parties to give up some rights and reach a compromise to get a sure thing. Because what you go down to the courthouse and get is not a sure thing. You may get something you can't live with from a jury or a judge, but you might be able to strike a deal about something you can live with in mediation. And what is mediation? It's a very similar word to it is arbitration, and they're similar but different. Now, I'm only going to talk about mediation in this scenario, and that's because arbitration is its own type of lawsuit. It's a litigation that doesn't involve the public courts of the United States of America or the states, the 50 sister states. It is different, and I'll address it in a subsequent video. And mediation is where the parties agree, or if they can't agree, the court will select a competent, experienced attorney in that realm of practice, family law, probate law, civil litigation, plaintiff or defense work, somebody who's done a lot of work, usually been practicing a long time and has a good toolbox of experience to delve into and advise the clients on 2 big things: where they need to compromise on the case, and if they decide not to compromise, where the judge might rule or a jury might rule in their particular county on the issues in the case. So